Hello. Yes, I know this is the second Depuy Pinnacle HIP litigation podcast of the week, but a couple of our members wrote in such good questions. I said, these cannot wait till next week, especially since you know me. If I wait till next week, by then I'll have another topic and they'll get lost. So we're going to answer a couple of the emails that we got, which I, in my old ways, call letters. But I got a couple of emails that have to do with the topic of the attorney's fees and the liens, et cetera, et cetera. They were excellent questions. I'll read maybe the first name of the person who sent each one of them, and we'll get into them. Again, before we get started, though, if you'll just look down at your software or whatever program you're using, whether it's Himalaya or Google or whatever, to listen to this podcast, please see where it says subscribe, actually. Hit that subscribe button. And if there's a thumbs up and a thumbs down, I'm going to wait till you hit the thumbs up, and then we'll proceed. We'll get right into the meat of the matter. Still waiting. Okay, there you go. Now, that's all you have to do, okay? Now, let's get into the first question, which I thought was a really good one. A gentleman named Craig from Denver wrote, how do we get somebody to listen to us if we think that we have been overcharged by our attorney? Well, I barely touched on that. I did get into that in yesterday's podcast, but let's talk about it now. California, and I believe almost all other states, in fact, it might be all other states, has a program where they understand that you're not able to go toe-to-toe with your attorney. You can't go to court. You can't file a lawsuit against them and litigate it out in court, and they're going to bring in their experts, and they've got all their money to fight you with. So the bar, which is the agency in each state that licenses the people to be attorneys, has in all 48, 49, 50 set up a program which allows an arbitration of the fee. A lot of good, a lot of bad to be said about arbitrations, but it's the important thing for you is that to know that it's there, and the one thing it certainly does is it levels the playing field. And what that means is that even if, now write this down, if you're seriously thinking of trying to negotiate the attorney's fees you've paid, even if your case is over and you've paid the attorney, you have the right to contact the bar in your state and say, I think I was overcharged. Now, it's important that you don't let your good nature get to you and say, well, no, I couldn't have been because they charged me exactly to the penny what the contract said. No, the bar is more on your side than that. I believe you weigh way too much on the client's side, but we'll get into that another time. But the bar will get into it and say, you're allowed to redo that contract, to have us review and rewrite it so that it results in a fair fee. If the fee that you paid, even though it was the one you agreed upon, is not a fair fee, now that we look at it in light of how the case ended up, then you're entitled to have the bar toss out that contract and instead come up with what would have been a fair fee and tell the attorney, that is what you get to keep, Mr. Attorney, and everything over that amount you've got to give back to the client. And of course, the attorney screams and says, but we had a written contract, we had an agreement. Well, if it resulted in an unfair award to the attorney, then it's too bad. Whether it was written or not written, the client is entitled to have the fee lowered down. Isn't that something? How come your attorney didn't tell you that? In many states, your attorney actually has to tell you that, but I never see it happen. Let's move on from there. So how do you do that? Well, you just go online to the local bar. Now, if you're in Denver, you would go to the Colorado State Bar, and I've looked at their webpage. There is a provision right there that says fee arbitration. So you would fill out the section that says fee arbitration, and the next thing you know, for very little or sometimes nothing, the bar will, first they'll send you out forms to fill out saying, what's your side of the story? Why do you think that you deserve to have the fee reduced? And the next thing they'll do is they'll set up very quickly, we're talking like within 3 months, they'll set up a hearing whereby you can present to the arbitrator your side of the story, why you think the fee is too high, and there will be an attorney from the law office that represented you, almost certainly not your attorney because it's just too humiliating, and they will come in and say why it is they think the fee is that you were charged was fair. Now, one of the sneaky things that a lot of insurance companies do is they pay their employees to do all of these arbitrations. And that way they have a tremendous say over who gets paid what, which attorneys get paid what, and they find it helps them get away with settling cases so that the attorneys don't want to screw around with the insurance companies. It's hard to explain that, but that's why there's very little doubt that when you get the notice, who's going to be the arbitrator in your case? It'll be an attorney, not a judge, but an attorney who's taken a course on arbitration and who just happens, as a matter of fact, to work for an insurance company, fighting off claimants like you. So he's not on the side of claimants. He's on the side of big business. Let's move on from there, though. A woman named Marianne from Dallas, okay, that's appropriate, wants to know, well, it says that I touched upon the topic of $500 was what my attorney would be. We're talking about the multiplier, the hourly multiplier. So in other words, if we have the expert that we know, or we figure out that the attorney has expended about 20 hours on the case, and we're trying to figure out what then should the attorney be paid out of the case, I said, well, I'd offer them about $500 an hour. That's a very generous fee, times 20 hours, so they get $10,000, and maybe we'd offer them a little bit more, and just in goodwill, thank you, and here's towards copying and things like that. Especially if they blew up any pictures. I don't see why they would if you hadn't gone to trial, but blowing up exhibits, man, that's expensive. Making a huge picture of your hip and a huge picture of the Depuy Pinnacle and things like that. Wow-wee, does that get expensive. So Here's the thing, that that $500 that I said, that's what I would offer the attorney per hour, which is a very generous fee for work in and around Dallas. The question was, well, what factors would make it go up and what factors would make it go down? And let me explain that again. In other words, let's say you're sitting at the kitchen table and you want to figure out what do you think is fair to offer the attorney. Now, I'm not talking about what does the contract say. I'm talking about, we're going to go in there and say, I know the contract says one thing, but we believe the contract resulted in an unfair amount of fee, an unfair fee to you, Mr. or Mrs. Attorney. So here's what we think would be a fair amount. Here's how that goes down. One of the first things we look at is the result, okay? If there was a result that definitely made your attorney stand out from other attorneys, then your attorney is entitled to a higher number. They would go more up towards $600 an hour, or maybe even higher, although I've never seen it. On the other hand, let's say you got less money than anybody else you know. Everybody else with similar cases, and I don't believe in similar cases. I think they're all different like snowflakes. But okay, so everybody you know with similar cases got $250,000 and you got $150,000. Well, then you would want to start turning that multiplier down and saying, no, I don't want to give you $500 an hour. I think you did crappy work. You don't have to throw that part in. That's what you're saying. If you say, I think I'm going to offer you $150 an hour, and you show me why I should have to pay more than that. Some of the other factors, well, I'm going to go through all of the ones I know. If your attorney had to do any out-of-the-office work, that really impresses the arbitrators. So if your attorney went and attended, let's say, an autopsy to see how the hip works, went to the local medical school in Dallas or wherever, and looked at a hip and watched a surgery of a hip while somebody was asleep so that he would be a better advocate for you, boy, that kind of thing turns that dollar figure back up. Now you're back $450, $550 an hour, okay? That's very impressive. Now suppose your attorney has experience or expertise, which is not quite the same thing, and in the field of either product liability or hips, artificial hips. That would allow them to charge more. So let's say you look in there and you think your attorney put in, we're going to pull out a number, 20 hours. But your attorney also wrote the book on product liability cases in Texas and how they're fought in the courts. And your attorney also wrote a book on the Depuy Pinnacle hip litigation and what's the best way for attorneys to maximize their clients' cases. Well, then your attorney would be worth more than the $500 or maybe $600 an hour. You know, I can't be specific as to what they're worth, but again, that would drive their value upward. How long they've been in practice? If your attorney's been in practice 1 year, well, let's head back down towards we're going to offer you $200 an hour. If your attorney's been in practice 35 years, well, now you're back up at $556, maybe $700 an hour, something like that. So those are some of the things that you would be looking for. Let's look at some of the things, some of the negatives. Has your attorney lost any of the cases, Depuy Pinnacle? I haven't heard of anybody losing any, but did the insurance company convince him to drop some cases? It's hard to find that out, but if you hear that he is actually dropping clients because he's not willing to fight for them, I would throw that in there, and I think you have a good chance that their hourly multiplier would go back down. Not quite as big a factor, but awards and recognition. Let's suppose your attorney last year got recognized as top litigant for the county or best trial attorney in your county. Even though they didn't do a trial in this one, I don't think, that's something that would allow them to collect more money. If your attorney has extensively traveled, let's say lecturing on this topic or any similar topic. So let's say they've gone to the University of Zurich and lectured there to medical or legal colleges about lawsuits pertaining to artificial hips. Well, that would make your attorney more of an expert, and that would entitle him to collect a larger percentage of the fee, and the way that's done is by increasing the multiplier. So maybe they would get up to $600 an hour doing something like that. Now, we're going to come to the crucial one, and this is a tough one. Well, what are you going to do about the fact that your attorney didn't sue your doctor? That's a tough one. Your attorney didn't sue your doctor. The laws are quite clear. It doesn't matter what state you're in. Your attorney, if he looks and sees that your doctor is one of the people that might have come up with money for you or might potentially have been found guilty, he can't not sue the doctor without your okay. He has to come to you and get your written okay to say, is it all right with you if I don't sue the doctor? Now, I don't see why anybody would sue the doctor. And let me tell you, when I called my attorney and got his assistant and asked, why didn't you sue my doctor? She gave me a story that said something to the effect of, well, we look like it would be just a lot of extra effort and you can't collect twice. and we wouldn't want an empty chair, which all of that is nonsense. All of that is craziness. What would have happened